Welcome back to Organized, the business law breakdown. I'm Seth C. Orenberg, and today we're talking about the magic moment in contract law known as acceptance. When you accept an offer, you can instantly turn a mere conversation into a legally binding agreement. But here's the question. What happens when an acceptance doesn't exactly match the offer? Imagine you're buying a car and the seller offers it for $10,000. You respond, "I'll take it, but can you throw in an extra set of tires?" Did you just accept the offer and create a contract? And if so, does that contract include the tires? Or did you make a counteroffer that killed the original deal? Today, we're breaking down how acceptance creates or sometimes destroys a contract. In our last episode, we looked at how offers can expire or be terminated before they turn into contracts. But what happens when the offeree actually accepts while having the power of acceptance? That's when we get into one of the most important principles in contract law, the power of acceptance and acceptance itself. And just like with offers, there are rules that determine when an acceptance counts and when it doesn't. Today, we're covering two big ideas: the mirror image rule under common law, where acceptance has to exactly match the offer, and the Uniform Commercial Code's more relaxed battle of the forms, where contracts can be formed even if the acceptance doesn't mirror the offer perfectly. We'll also take a look at the mailbox rule, which can create some surprising results when communication is delayed. Before we get into the details, here are three key takeaways for today's episode. You'll learn how the acceptance of an offer must mirror the terms of an offer exactly, without any modification, for a contract to be formed under common law. We'll explore how a response that changes or adds the terms of an offer is treated under common law as a counteroffer, not an acceptance, and we'll see how this affects the formation of a contract. And we'll discuss important exceptions to the mirror image rule, including Uniform Commercial Code Section 2207, which governs contracts for sales of goods and allows some flexibility in offer and acceptance terms. So, whether you're negotiating a deal or just clicking "I accept" on terms and conditions, stay with us. We're about to find out when a simple acceptance turns into a binding contract and when it doesn't. Now that we've set the stage, let's talk about what makes an acceptance legally binding. At its core, acceptance is the offeree's way of saying, "Yes, I agree to the terms of the offer." But the form that acceptance takes and whether it's considered valid depends on whether you're operating under a common law or the Uniform Commercial Code. Under common law, we have what's known as the mirror image rule. For an acceptance to be valid, it has to exactly match the terms of the offer, no deviations. If the offeree changes or adds anything to the offer, it's not an acceptance at all. It's a counteroffer, and the original offer is off the table. Let's go back to our example and say a seller offers to sell a car for $10,000, and the buyer responds, "I'll take it, but I want an extra set of tires." Under the mirror image rule under common law, that would not be an acceptance. That would be a counteroffer. The buyer's addition of the extra tires changed the terms of the deal, so the original offer is terminated and replaced with a new offer that the original seller, can either accept or reject. Things get a little more flexible. We move into the world of goods under the UCC. The UCC rejects the strict mirror image rule in favor of what it calls the battle of the forms. The rule comes into play when businesses are exchanging forms that don't match up perfectly. Even if the offeree's acceptance includes additional or slightly different terms, a contract could still be formed so long as the changes aren't material and the original offer didn't specifically require matching terms. So picture this. A peach farmer offers to sell 15 dozen peaches for $300 to a grocery store. The grocery store sends back a response agreeing to the price, but says they want 14 dozen peaches instead. Under common law, this would be a counteroffer, not an acceptance. But under the UCC, If both parties are merchants, the contract would probably still be valid because the terms are close enough and the change would likely not be seen as material. And then there's the mailbox rule, a quirky timing issue in contract law that may feel anachronistic, but did arise when we had the Pony Express. While most communications like offers and rejections are effective when they're received, an acceptance is different. An acceptance is valid from the moment it's sent, not when it's received. So if you send a letter accepting an offer but change your mind and send a rejection the next day, the acceptance is still valid because it was sent first. So whether you're dealing with the strict mirror image rule of common law or the more relaxed battle of the forms under the UCC, understanding the rules of acceptance is crucial. The difference between a simple I accept and a counteroffer can mean the difference between a contract and no deal at all. Now that we've gone over the key concepts, let's break it down with some real-world examples of how acceptance plays out in the courts. Let's break it down with two cases that show how acceptance plays out in the real world, or at least the legal world. Starting with Providence and Worcester Railroad versus the State of Rhode Island. This case illustrates how modern courts don't always stick to the strict interpretation of the mirror image rule. In P&W Railroad, a railroad company, Providence and Worcester Railroad Company, offered to sell land to the state of Rhode Island. The offer included the company's promise to remove railroad tracks from the property at the company's own expense. The state responded by accepting the offer, but essentially saying, "Don't worry about removing the tracks. We'd actually prefer to keep them." So, did the state's response count as an acceptance, or was it a counteroffer? The railroad argued that since the state changed the terms of the offer by saying the tracks could stay, that made it a counteroffer. However, this court disagreed. They sort of called shenanigans because a little backstory to the case is that the reason the company made the offer to the state is they were required to do so by statute. Maybe they didn't really want that deal. The court ruled that because the state's change benefited the railroad company by saving them the cost of removing the tracks, this was still a valid acceptance even though it was a change in terms. Again, maybe the circumstances impacted the way the court chose to rule in the case. In any event, the case shows that minor changes in acceptance, especially if they benefit the offeror, may not automatically kill the deal under the modern interpretation of the slightly less strict mirror image rule. The key takeaway here is courts often apply common sense when interpreting whether minor changes in acceptance turn an acceptance into a counteroffer. If the change is immaterial or benefits the offeror, modern courts may still enforce the acceptance. Now let's look at a classic example of the UCC's battle of the forms in action, in the case of Flender v. Tippins. In this case, Tippins, a company constructing a steel mill, ordered custom-made gear drives from Flender. Both companies exchanged forms with different terms. Tippins' form required arbitration in Vienna, Austria, while Flender's forms required litigation in Chicago. Those are rather different forums. Here's where things get interesting. The court ruled that these competing terms were both knocked out of the contract. This highlights the knockout rule of the battle of the forms. Neither arbitration nor litigation in either location was accepted because the forms didn't match. The parties did form a contract, but it did not have a choice of litigation or arbitration venue provision. Instead, the court filled the gap with the UCC's default rules and let the case proceed in good old Pennsylvania. The case shows how the battle of the forms works under the UCC. Even though the forms didn't match exactly, a contract was still formed based on the terms that both parties agreed to. Conflicting terms were eliminated. The lesson from Flender v. Tippins is that under the UCC, minor differences between the offer and acceptance don't necessarily prevent a contract from forming. If the parties' forms don't match, the conflicting terms are knocked out, and the UCC fills in the gaps. So, what do these cases tell us? Under common law, courts can be flexible when interpreting the mirror image rule if the changes benefit the offeror. And under the UCC, the battle of the forms allows contracts to form even when the terms don't match perfectly. In both cases, the court looked at the overall intent to create a contract rather than getting hung up on minor differences. Now that we've seen how courts handle acceptance, let's test it out with a what-if scenario. Here's a scenario. A seller offers to sell a painting for $5,000. And the buyer responds by saying, "I'll take it, but I need you to frame it before delivery." Did the buyer accept the offer and create a contract, or did they make a counteroffer? In this case, the buyer's request for framing would likely be seen as a counteroffer under the common law's mirror image rule. The buyer didn't accept the exact terms of the offer. They've added a new condition about framing. This means the original offer is terminated, and now the ball is back in the seller's court to accept or reject the new terms. Let's try another one. Imagine a business offers to sell 100 laptops to a retailer for $50,000, and the retailer responds with an order for 100 laptops at the stated price, but adds a clause saying they want the shipment delivered in 10 days instead of the typical 15 days. Under the UCC, is this a valid acceptance or a counteroffer? Under the UCC, this would still be a valid acceptance. The change in delivery time probably does not materially offer the terms of the contract. It's not like the laptops need to be specially manufactured or anything like that, which would materially change the time period required to do the contract. The acceptance stands, and the contract is formed. The UCC's battle of the forms is much more flexible than the common law, and minor changes like delivery time are often seen as part of the ongoing negotiation. Finally, let's throw in a twist with the mailbox rule. Suppose a buyer sends a letter rejecting an offer on Monday, but later that day they change their mind and send an acceptance letter. If both letters are sent before the seller receives either, is there still a contract? Yes. Under the mailbox rule, the acceptance is effective the moment it's sent, even if the rejection was sent earlier. As long as the acceptance was sent before the rejection was received, even if just by a minute, it creates a binding contract. In this case, the rejection letter doesn't come into play because the contract was already formed when the acceptance was sent. So, as these examples show, the rules around acceptance are all about timing and matching. A slight change in terms can turn an acceptance into a counteroffer under common law, but the UCC offers more flexibility. And with the mailbox rule, the timing of when an acceptance is sent can sometimes override a rejection. Next, let's explore how these rules pop up in the world of pop culture. Let's take a look at the concept of acceptance. One of the most common places we encounter acceptance is when we agree to terms and conditions online. You've seen it every time you sign up for a service, download an app, make an online purchase, or even agree to have your privacy stolen by companies which are offering you the option to opt out of cookie tracking. You've seen it all the time, and you've probably simply clicked, "I accept." Have you ever thought about what you're actually accepting? These click wrap agreements, as they're called, are legally binding once you click "I accept." Even though there's no negotiation and you can't change the terms, these are so-called contracts of adhesion. They're a little sticky. Clicking that button counts as an acceptance of the offer, and you're agreeing to all the terms, whether you read them or not. So, next time you click "I accept," think of it like signing a contract. You're creating a binding agreement. Now let's shift gears and look how acceptance plays out in some movies. In The Social Network, there's a moment where the Winklevoss twins are offered a settlement by Mark Zuckerberg, but instead of accepting the offer right away, they hold out for more. By not accepting the offer and trying to negotiate better terms, they risk losing the deal altogether. And that is what happened. This highlights how the concept of acceptance is critical in real-life negotiations, especially in high-stakes situations where timing and exact terms can make or break a deal. Whether you're clicking I accept online or trying to negotiate a settlement like in the social network, the rules of acceptance are always at play. The moment you accept, you've entered into a binding agreement. But remember, if your acceptance changes the terms, you might just find yourself back at square one as the offeror of a counteroffer. Let's wrap up with a quick recap of today's episode. We started by exploring the rules of acceptance. How, under common law, the mirror image rule requires that acceptance must exactly match the offer. But in the real world, things aren't always so clean. We also saw how the UCC's Battle of the Forms allows for flexibility in contracts for sales of goods, where minor differences between the offer and acceptance won't necessarily kill the deal. In our Break It Down segment, we looked at Providence and Worcester Railroad versus State of Rhode Island, where the court bent the strict mirror image rule to enforce a contract. And we looked at Flender v. Tippins, which highlighted how the UCC's Battle of the Forms works out with a knockout rule application when the offer and acceptance didn't match perfectly. The key takeaway? Whether you're negotiating a business deal or simply clicking I accept online, the rules of acceptance are crucial. A valid acceptance can lock in a contract, but if your response changes the terms, you may end up being the offeree of a counteroffer instead, and you risk losing the deal. As always, I'd love to hear your thoughts. Have you ever accepted terms online without thinking about it? Or have you negotiated a deal where a small change turned into a counteroffer? Share your experience or questions with me. I may even cover them in a future episode. Don't forget to subscribe, leave a review, and share this podcast with anyone who might find it helpful. In our next episode, we'll dive into the rules around consideration. That's all for today's episode of Organized, the Business Law Breakdown. I'm Seth C. Orenberg, and I thank you for exploring the acceptance piece of mutual assent with me today. I hope you found it informative and helpful. Remember, until next time, keep your agreement strong and your arguments stronger.